Hello, to continue with our discussion. Okay, so last time we talked about the formalities of organizing a corporation, the promoters, the subscription contract versus the purchase agreement. We also started discussing the articles of incorporation by talking about the corporate name, which is one of those which must be stated in the articles of incorporation as part again of the formalities of organizing corporation. Now, to continue, let us talk about the purpose of incorporating or the purpose of the corporation. Under the Corporation Code, it's stated that all corporations organized under the Corporation Code shall file the AI stating therewith the specific purpose or purposes for which the corporation is being incorporated. Okay. And in the case of Hui Shulyong versus Director, the court had the occasion to note that the AI can state more than one purpose. What happened in this particular case was that Hui Shulyong and his cohorts was originally a partnership. Okay, so it was earlier formed as a partnership, a simple type of business organization. Eventually, they decided maybe to expand, and that's why they decided to dissolve the partnership and to form a corporation to be known as the Shulyong E Compania. Okay? And the purpose is to, number one, acquire the business and to continue the original purposes of the partnership. And then another one is to engage in retail trade. And the third one is to engage in banking. Okay? So the director of the Securities and Exchange Commission disallowed this. Okay? It did not register the newly formed corporation because according to it, it cannot have more than one purpose. Okay? There were many purposes stated in the Articles of Incorporation of Shulyong E Compania. Okay? And that's why Shulyong, of course, and his colleagues decided to file a case to question the decision of the director of the SEC. And here, the court, as I've already stated, said that yes, the AI can state more than one purpose. Okay? The provisions of the proposed AI of Shulyong E Compania is only incidental to the principal purpose of the company. And what is the principal purpose? According to the decision, it is to engage in the mercantile business. Okay? So, it is broad species of purpose or of an objective to engage in mercantile business, and that under our laws, Philippine corporations may engage in a business with more than one purpose, and that's why the petition was granted. Okay, so note that a corporation may be organized under Philippine laws for mercantile purposes and to engage in such incidental business as may be necessary and advisable to give effect to and aid in the successful operation and conduct of the principal business. That was how the court justified its decision in this particular case. Okay? It's also said that we have arrived at the conclusion that the proposed articles of incorporation do not authorize the petitioners to engage in a business with more than one purpose. But this does not mean that corporations under the laws of the Philippine Islands may not engage in a business with more than one purpose. Okay? Because according to this decision, an interpretation, that interpretation will work a great injustice to corporations organized under Philippine laws. Okay? It will give foreign corporations which are permitted to be registered under our laws and which may be organized for more than one purpose a great advantage over domestic corporations. And according to the court, it does not believe that it was the intention to limit corporations into just one specific purpose. So, let us go back again to how this works. First, can a corporation have more than one purpose? The answer is yes, it can. Now, can a corporation have more than one primary purpose? No. That is where that is not allowed. Hindi pwede. Okay? more than one primary purpose. Now, can it have secondary purposes, and how many it can have secondary purposes as long as it wants, and as many as it wants. Okay? Now, dapat ba connected si secondary kay primary purpose? Well, we used to think that it should be connected, but no. Okay? It does not necessarily mean that the secondary purposes are connected with the primary purpose. Okay? Now, why is it then important that a corporation have only one primary purpose as opposed to its secondary purposes? Okay? Kasi sabi nga sa batas, where a corporation has more than one stated purpose, the AI shall state which is the primary purpose and which is the secondary purpose. Yun ang kailangan merong delineation. Ano yung primary mo? Ano yung secondary mo? While you can have only one primary purpose, you may have more than one secondary purpose. In fact, as many as you want. Okay? And the reason for this is monitoring. Okay? So, it is the primary purpose that the state or the government will monitor and will regulate. Okay? And in terms of the contract between the incorporators as well as the shareholders of the corporation, then it is the main business which is looked into, di ba? For purposes of investment. Alin ba ang primary purpose? Ano ba talaga ang reason for creating that particular or establishing and creating that particular corporation? Okay? And in a way, the primary purpose also limits what the management can do. Diba? Hindi yung parang disabog na lahat kinuha. So, it serves both a legal as well as practical purpose. The fact that there is only one primary purpose, but there can be more than two. In fact, 3, 4, even 5 secondary purpose. Okay? So, take note of that. Doon tayo tititig sa primary purpose. Nag-iisa lang, pero pwedeng merong ibang secondary purpose. Now, of course, another content of the articles of incorporation would be the place where the principal office of the corporation is to be located, and it states there that it should be within the Philippines. Now, why is this important? Okay. In Clavecilla versus Antillon, the New Cagayan Grocery filed a complaint in the court in Cagayan de Oro City for damages against Clavecilla Radio System. Okay, so we have two corporations. Because according to New Cagayan Grocery, Clavecilla Radio System made a mistake in transmitting a telegraphic transfer. So, nag-send ng telegrama, mali ang nailagay sa telegram. So, this is a case of torts. Okay? And damages, of course. So, Clavecilla moved for the dismissal of the case on the ground that venue was improperly laid. So, mali daw yung venue. According to Clavecilla, the case should have been filed in Manila, not in Cagayan de Oro. Okay? Because it is in Manila where it has its principal office. Okay? The judge ruled in favor of New Cagayan Grocery and said that as far as it was concerned, then venue was correct, as the company, meaning Clavecilla Radio System, can be sued either in Manila or in Cagayan de Oro, where it has a branch office. Okay? So, on appeal, the court affirmed the decision, hence Clavecilla Radio System went up to the Supreme Court. Okay, so the question in this case is, where is the residence of the corporation where the suit should be filed? That is the question. Alin ba? Dapat ba? Saan ba? Sa Maynila, principal office, or kahit saan na may branch office? Okay? So, for purposes of cases such as this, court held that the residence of a corporation is where the principal office is. and therefore the case should have been filed in Manila as correctly contended by Clavicilia Radio System. Okay? Because to allow an action to be instituted in any place where a corporate entity has its branch offices will result in confusion and inconvenience to the corporation. Okay, so just imagine, di ba, kunwari, Jollibee, although we know that Jollibee operates based on franchise, but let's say, okay, and that Jollibee has a principal office in Makati, and then it has branches everywhere, okay, all over the Philippines as well as abroad. So iyon, parang ganon yung point nila. To allow that would inconvenience the company, okay, especially companies which has not just main office but also other branches. Okay? So, sabi nga, settled is the principle in corporation law that the residence of a corporation is the place where its principal office is established. Okay? And since it is not disputed that Clavicilia Radio System has principal office in Manila, then the suit should have been filed in the city of Manila. Okay? And that was what the court said. So the residence class, no, the principal office is important, especially in terms of filing suit. So dapat alam mo saan ba principal office nito. No? Kasi nga, there might be branches, but in order for you to properly lay the venue in case a suit is filed, then it should be in the residence, and the residence is in the principal office. So that is the address that you're going to use. Okay? Now, corporate term. Of course, one of the major amendments to the corporation code, the old corporation code, when it was revised way back in 2019, was corporate term. In the old law, the old corporation code, it says that a corporation shall exist for a period not exceeding 50 years from the date of its incorporation unless sooner dissolved or unless said period is extended. Baligtad na po tayo ngayon. Okay? So remember that. Sabi na natin, no, during the first day of class, I already mentioned that it is one of the major amendments or revisions in the code. Baligtad na. Ang default na ngayon, hindi yung 50 years. Ang default is perpetual existence of the corporation. And the exception now to the rule is if you want to put in a term, if you want to say that you're only going to last for 50 years, that's it. Baligtad na. Unlike before, the default was 50. The default corporate term was 50 years, which is extendable for another 50 years. So you have to renew it. Okay? So, we will not anymore discuss the cases on corporate term since it will no longer be applicable. But suffice it to say, let's say, that what is the effect, let's say, of the end of corporate term? Kasi exception pa naman siya. Hindi pa naman impossible na mangyari that a corporation would opt to have a term rather than the default, which is perpetual existence. So, in Alhambra Cigar and Cigarette versus Securities and Exchange Commission, okay, says that, let's say, no, a corporation is dissolved, it continues as a body corporate for another 3 years. To what? To wind up its affairs. Okay? So the continuance of a dissolved corporation as a body corporate for 3 years has for its purpose the final closure of its affairs and no other. That is the effect. So let's say, no, that it is not for perpetual existence. Ayaw niya, gusto niya doon siya sa exception, di ba? Maiba naman. Okay, di bale na. I don't want to exist in perpetuity. I don't want to stay, no, as a corporation forever. So let's put in a term. Sabi niya 50 years. Now, after 50 years, what will be the effect? For all intents and purposes, it is already dissolved. But it will continue as a body corporate for winding up of its affairs. Okay? That is the effect if there is still a term. Okay? So, kasi dito, diba, natapos. So, 50 years and then later on, no, nag-expire na. Okay? So, it ceased transacting its business and entered into a state of liquidation. That was the what happened in this particular case. So later on, there were issues which arose on ano ba talaga and what can it do during the time that it has ceased to exist because of the end of the corporate term. And that's where the court said that the liquidation of the corporation's affairs set forth in the law is necessary precisely because its life had ended. Okay? So the corporate existence and juridical personality of the corporation to do business may no longer be extended. That is the effect if a corporation chooses not to exist in perpetuity and decides to have a corporate term. Now, so since it is already in perpetuity, yung mga old cases natin in relation to when to extend its corporate term may no longer be applicable. But it is good to know that yun nga, before kasi pwede pa rin namang mangyari na may corporate term siya, etc. Now, what is the way so that you can extend your corporate term? Diba? Dito sa Benguet Consolidated versus Pineda, a 1956 case, the issue was whether or not Benguet Consolidated can extend its corporate term either by amending its articles of incorporation or by incorporation. Okay? So, according to the decision, you cannot just extend your life by amending your AI. Okay? So, you have to do this prior to before. Dapat na provided yun doon. Okay? So, the possibility to extend the corporate life is okay as long as it is already provided that you can extend it. But yung mga last minute decision, yun ang sinasabi ng Benguet, yung mga parang parang dinadaya mo yung state, diba? What you are trying to do something which you are prohibited from actually doing. Sabi natin, sinicircumvent mo. Then, that's the time when the court will say, no, you cannot do that. Diba? What you cannot do under the law, you cannot do with the simple expediency of changing your AI. Okay? Because the right to exist is not a vested right. So, we go back again to what we discussed during the first meeting, that the right to exist of a corporation is not absolute. Okay? It is a grant to it. It is a mere privilege given to it by the state. And as I think I mentioned then you must be in good behavior. Okay? You must comply with all of the requirements under the law. You must comply with all of the directives of the state so that you can continue existing. Okay? So, hindi pwede na basta gusto mo. Hindi pwede, I will, continue on forever. Especially during the early days prior to the amendment of the code wherein there was claro, definite corporate term. Okay? Unlike ngayon, that is now the exception rather than the rule. Okay? So, as to the number and residency of incorporators, it is still the same rule. 5 but not more than 15. But I've already mentioned that meron tayong one-person corporation, which is a new animal introduced by the revised corporation code. We are going to discuss that separately. Okay? But dun muna tayo sa dati, meaning nung wala pa yung one-person corporation. So, for the regular corporations, I would like to call it the ordinary corporations or regular corporations, then meron pa rin tayo doon na number and residency of incorporators which is required under the law. Meron pa rin minimum capitalization, meron pa rin tayong mga subscription and paid up requirements. Okay. Now, when can the Securities and Exchange Commission disapprove your application. Okay, sabi nga natin kanina, di ba? Or no, not kanina, but in my other lecture, if you will remember, I said that there's now a form that you can just fill out and then submit to the SEC, attach all the documentary requirements, and that's about it. You can already, that already serves as your application. But what are the grounds for disapproval? So the usual grounds for disapproval provided under the law are that the AI, or any amendment thereto, remember, if you amend the AI, it's like you're submitting a new AI. Take note of that. That is the effect. When you amend an AI, it's like submitting a new AI. So it must also be approved. Hindi lang yon a matter of amending your AI and that's it. Diba? Parang magic, okay na. It also has to go through that, the approval by the state, because you are amending the contract technically. Remember, we said that the AI serves as the contract. So, if you're amending the contract, hindi pwede na unilateral. So, meron ding approval ng secretary, ng Securities and Exchange Commission or the state. Okay? So, if it is not in accordance with the form prescribed, kaya nga mas maganda para hindi ka na malito, mangopya ka na lang. Diba? Sabihin in the sense that you follow the form, meron namang prescribed. No? Or that the purpose, of course, or purposes, whether primary as well as the secondary purposes or any additional purposes you would like to add to AI are patently, of course, unconstitutional, illegal, immoral, contrary to government rules and regulations. Claro, very clear na iyon yung isa sa libra, illegal, diba? Bawal yung gusto mong purpose. Then, the treasurer's affidavit in relation to the capital stock is false, no percentage of ownership, and that's why we talked about it before. What is the importance of the ownership, diba? The nationality of the corporation. Okay? So that the percentage of ownership of the capital stock to be owned by citizens of the Philippines has not been complied with as required under the Constitution. So, di ba, kunwari, ang corporation mo, ang primary purpose is for natural resources, di ba? Tapos, more than 50% owned by foreigners. So, yun, hindi siya nag-comply. Okay. So, articles of incorporation of or amendment to the AIs of banks, banking and quasi-banking institutions, including loan associations, trust companies, and insurance companies, etc., public utilities, all of these, those which are imbued with public interest, no, kailangan may recommendation ng additional government agencies na nagmo-monitor sa kanya. So, for instance, for banks and other financial institutions, dapat may favorable recommendation ng Bangko Sentral ng Pilipinas. Okay? So, may mga additional requirements. Hindi lang yan yung nandun lang sa SEC na requirement. So, if it's a specialized industry, or if you're going to engage in business which is highly regulated, then you need to have this additional requirements. So, for instance, insurance company, kailangan ng favorable recommendation by the insurance commissioner, or the insurance commission. Yan yung mga sample. Educational institutions, CHED. Diba? Yan ang mga tinitingnan dyan. So, may additional layer of monitoring and regulation. Yun lang naman ang sinasabi doon. Not just compliance with the basic the general law, the corporation code, as well as the rules and regulations of the Securities and Exchange Commission, but you also have to consider other requirements of the authorities. Gaya nga ng Bangko Sentral, Insurance Commission, CHED, depending on the type of business or endeavor that the corporation is going to engage in. So, when we say lawful purpose, what do we mean by that? One example was, as discussed in the case of Asuncion versus Leriarte. Okay? So, Asuncion, and his colleagues proposed to form a corporation with the purpose of organizing and regulating the management, disposition, administration, and control uh, of the Barrio Opulo or San Miguel in relation to their common property, okay, including the use of their natural resources, okay, and for civic and charitable works. Take note, class, this was a 1914 case. So, medyo ano pa to? Medyo matanda na. Okay? So, the Iriarte, who is a government official, refused to file or accept the articles of incorporation on the ground that according to him, the purpose of the corporation being proposed by Asuncion, no, was not lawful because it violates Section 6 of Act Number 1459, meaning what they're trying to register is not registrable. Okay? So, syempre, nag-inarte sila Asuncion, sabi nila, we're going to go to court, we're going to question your decision. Okay? So, the issue is, tama ba si Asuncion that they can register the corporation with the purpose as so stated in their articles of incorporation? No. That was the court's decision. The Supreme Court held no, the purpose or the object of the proposed corporation is illegal. How? Because the object is to make of the Barrio Opulo or San Miguel a corporation which will have ownership over and control of property belonging to the municipality of Pasig. Okay, so Pasig pa nun to, Pasig Rizal, 1914 case. So yung Barrio Pulo and San Miguel in Pasig, in Rizal, yun ang gusto nila na parang maging korporasyon, private corporation at that. No? The intention might be good to manage the barrio resources, but it is illegal. Okay, it cannot be permitted because it is a municipality. No? You are going to take control and manage municipalities' properties. So, it would lead to a case wherein all municipalities would opt to form a private corporation to manage its affairs, and that is against the law, diba? Ano yan meron? Ngayon, meron tayong local government code. Before, it was some other law. But the idea is the local government units, even though it is considered as a municipal corporation, is a different being altogether. It is not private in character. Okay? It is a municipal corporation. While it can engage in proprietary functions, no, perform proprietary functions like manage slaughterhouses, manage cockfights, otherwise go into business, still the primary function of a municipality or a local government unit is sovereignty. Okay? It is for the sovereignty of the state. So, it is still a public function. Yun na talagang ginagawa nila. So, para gawin mo parang private corporation as Asuncion was proposing here, that would violate our laws. Okay? So, take note that what the law does not permit cannot be obtained by indirection. Diba? Yung sinasabi ko kanina, I was at a loss for words, sinicircumvent mo. So, if the law does not permit it, you cannot get it by some other means. Lang ang ibig natin sabihin. Okay? Now, what about the bylaws? How is it different from our AI? So, meron ka ng articles of incorporation. Tama yung purpose, nakalagay, how long you know, if you choose not to exist forever, nakalagay na yung corporate term, if that is your choice, then naka-indicate na yung mga principal address, even the incorporators, etc. So, everything, all of it, na-filled out na ng maayos, diba? Na-submit. So, what else? Okay. According to the law, the commencement of corporate existence is from the the time, that the Securities and Exchange Commission issues a certificate of incorporation under its official seal. So habang nandun lang yon, iintayin mo na aproban. Kaya nga tinitingnan pa kung legal ang purpose, kung tama yung pangalan, walang kamuka. So meron proseso na pinagdadaanan. Now, once a certificate is issued to you, then that's the time that you have corporate existence. Okay? And when, okay, you have that, what can you do? Thereafter, the incorporators, the stockholders/members, stockholders kapag stock corporation, members pag non-stock, okay, and their successors shall constitute a body politic and corporate under the name stated in the AI. So if it's ABC Corporation, that will be the name of the corporation, and it will now exist in perpetuity unless it decides that it wants to have a term and not be in perpetual existence, and it can already now start functioning, as a separate juridical personality. Okay. Now, what about the bylaws? Okay. We usually, read in the cases, it's not in the bylaws, or the bylaws, provisions in the bylaws are being invoked. So how important is this bylaws? Is it the same as the articles of incorporation? No. Okay? The articles of incorporation is what you submit to the SEC, and what the SEC checks, for compliance and everything. And if it follows all of the requirements, and that is what it is approved and is the basis now of the contract between the corporation and the state. Now, the bylaws on the other hand, ito yung internal. Okay? Yung isa, yung kontrata niya sa state, yun yung purpose ko, ito pangalan ko, ito kami. Pero yung bylaws, ito na yung sa second portion. What's the second portion or second level? Ito na yung sinusunod, di ba? Na susundin ng korporasyon in relation to how it will now deal with its stockholders or members, as well as maybe, third parties. Okay. Now, in the case of Loyola Grand Villas versus Court of Appeals, now this is considered as a fairly recent case compared with all the other cases in my syllabus. No? This is a 1997 case. Here, the Loyola Grand Villas Homeowners Association, was organized, and of course it was composed of the homeowners of this exclusive subdivision, Loyola Grand Villas, somewhere in Katipunan. And it was registered with the Home Financing Corporation. Ngayon, yun na yung isa, parang HLURB, mga ganon. Okay? Home Guarantee. And then, meron na siyang certificate of registration. Remember, I said, hindi lang sa SEC ang usapan natin ng pag-rehistro. In this case, as a homeowners association, ang kailangan mong registration is sa HLURB. Okay? So, after being registered, however, it did not file its corporate bylaws. Okay? So, later on, okay, it tried to register its bylaws. So, 1983 pa sila, pero 88 lang sila nagpaparehistro ng kanilang bylaws. Okay? So, later, they found out na meron palang ibang homeowners association. Merong north, merong south. Nag-usapan natin dito, class, ay hindi simpleng subdivision na parang tinitiran ko, di ba? Na maliit, isa lang ang homeowners association. Ito ay malaki. And you could just imagine, being exclusive, mayayaman na nakatira. So parang parang politika, parang maraming nag-aagawan sa pwesto at malaki ang perang involved. Kaya siguro, naging tatlo. So we have the original Loyola Grand Villas Homeowners Association, meron pa tayo na North, meron pang South. So lahat yata ng entrance at exit ay merong may faction dito. Okay. So later on, diba? alaman din nila na nakaregister din to. So, yun, meron ng tatlo. Diba? Ang dami na nila. Iba-iba ang dates ng registration. So, ano ba to? Sino ba talaga ngayon ang original at may karapatan na Loyola Grand Villas Association? Diba? Kulang na lang pataasin natin ang kamay na, okay, sino ba talaga? Si 1983, si 1989, and then meron pa yatang isa na 1987. Okay. So, sino sa kanila? Yung bang date ng kanilang incorporation, yung bang masusunod? So, which is which? That is the question in this case. Okay. And this, will involve looking into the date when they filed their bylaws. Sabi nga, whether the original Loyola Grand Villas Homeowners Association Incorporated, whether its failure to file its bylaws within the period prescribed by the Corporation Code had the effect of automatically dissolving the corporation. Kasi nga, ang issue natin, sino ba talaga? So, kung dissolve na siya, din yung dalawa na lang, di ba? At sino ngayon sa kanila ang talagang pupwede, di ba? At totoong Homeowners Association. Okay? So, the answer was that the failure to file the bylaws does not automatically operate to dissolve a corporation. In this case, the Loyola Grand Villas Association. Okay? It is, however, considered as a ground for dissolution, but not automatic. So, ground, pwede kang mag-dissolve kasi hindi ka nag-cooperate, kasi nga hindi ka nag-file ng bylaws. Kailangan mag-file ka ng bylaws within certain period after ka mag-incorporate. Okay? So, it is a directive for you to do that. Okay? That you have to file within 1 month or within that period na may bylaws ka na. Kasi it shows that you are now going to operate, that you have the full intention to exercise your primary franchise. Otherwise, di ba, at yun ang ayaw ng SEC, that you're going to incorporate and then wala lang, di ba? Parang parang nireserba mo lang yung pangalan, parang nireserba mo lang yung na mayroon kang korporasyon. Okay? And then wala ka pa naman palang balak to really do business or to operate. Okay? And there are lots of entities like that. Mag-rehistro pero wala lang. I think that yun din yung nagiging problema kasi later on, they might be considered as what? Dami corporations nagagamit sila for that kasi incorporated na sila but they have no intention of really doing whatever their purpose is. So later on, unscrupulous individuals might use the corporate shell, the registered corporate entity para saan? Para sa korupsyon o para sa illegal business. Kasi nandun di ba? Lalo na for those na hindi makapag-register for some other problems. And that's why they look up to these corporations which are already registered. Kasi para wala na silang problema. Kasi nakarehistro na yun. And that is what we try to avoid. That is one of the intentions, okay, for requiring that you file your bylaws already once you get your certificate of registration. Okay? But that it does not dissolve you automatically just in case you fail to do that. So yung original Loyola Grand Villas na to was not deemed dissolved simply because for whatever reason it did not file its bylaws within the period prescribed under the law. Okay? At the most now, it can just be a ground for dissolution, but it will not result in automatic dissolution. So, what is the effect of this bylaw? So, mahalaga siya. Kasi nga, it governs the conduct of those, okay, in the organization or in the corporation. Yun ang rule. Yun ang intent ng pagkakaroon ng bylaws. At least alam mo, meron ba akong right of first refusal? Paano ba mag-elect ng ng corporate officers, what are the rights of the stockholders, what are the limitations to the corporate powers. Yun ang nakalagay sa ating bylaws. But what about, okay, third parties, third persons? What is the effect of the bylaws, no? The provisions in the bylaws of a corporation in case a problem appears. Okay? So in the case of China Banking Corporation versus Court of Appeals, okay, can China Banking be bound by what is provided for under the bylaws of the Valley Golf and Country Club Incorporated? Okay. Kasi dito may isang stockholder ng Valley Golf, no, si Calapatia, and he pledged his stock certificate to the China Banking Corporation. Okay. And as I've said, sa bylaws meron palang silang mga rules in relation to the disposition of shares of stocks and the subsequent transfer siguro, no, of these shares of stocks. Remember in the earlier case of Benguet, diba, kaya ayaw niya na mag-transfer ng mga stock certificates kasi nga daw meron silang rules sa bylaws. So this is similar to that. But now, will it now bind China Banking Corporation? Considering that China Banking Corporation is not privy to it. Malay ba niya kung ano nasa bylaws, diba? Yang kausap niya si Calapatia, hindi naman niya kausap si Valley Golf and Country Club. Okay? So, the court held in this case that in order to be bound, the third party must have acquired knowledge of the pertinent bylaws at the time the transaction or agreement between the third party and the shareholder was entered into. Okay? But in this case, hindi nila alam, China Banking Corporation. Okay? At the time the pledge agreement was executed, the Valley Golf and Country Club did not inform or was not able to inform China Banking of its bylaws. Okay? Kasi, in-acknowledge naman niya na pledge ng shares. Remember, pledge is a type of disposition. Of course, the shares of stocks is property. Okay? So, pinledge ni Calapatia. Pumayag naman si Valley Gold na yes, okay, may pledge involving shares of our stock. Okay? But it did not, okay, inform, okay, China Banking Corporation kung ano pa yung mga dapat malaman ng China Banking in relation to the shares of stocks. It was only during the foreclosure stage already, kasi hindi siguro nabayaran ni Calapatia kung ano may inutang niya kay China Banking, noon na lang sinabihan ang China Banking na teka, may rules pa kami in relation to that. Okay? So, sabi, CBC's belated notice of said bylaws at the time of foreclosure will not suffice. Okay. And the court later on explained the nature of the bylaws. Sabi, bylaws signifies the rules and regulations of private laws enacted by the corporation to regulate, govern, and control its own actions, affairs, and concerns, and its stockholders or members, and directors and officers with relation thereto and among themselves in their relation to it. So take note of that. It is internal in nature. It is not like the articles of incorporation where there is what? An assumption that even if we haven't read it, because it was filed with the SEC, third persons might have seen it. So it binds us. Kasi kontrata yon between the state and the corporation. Pero yung bylaws, hindi. Internal yon. So it only regulates internal conduct. Corporation and its stockholders among themselves, vice versa. Iyon ang bylaws. So generally, kailangan malaman ng third parties before siya mabind. Kasi wala tayong kinalaman doon. Diba? You will not look into that. That is one level, diba, deeper. If you would still look into the bylaws, wala ka namang pakialam doon. Diba? As opposed to, let's say, you're just being diligent, di ba? Parang due diligence lang, tinan ko nga ang AI, ano ba nakalagay ito? Pero to go, no, beyond the AI and go into bylaws, internal na yon. So, iba yung rules in terms of binding third persons. Okay? So, the purpose of a bylaw is to regulate the conduct and define the duties of the members towards the corporation and among themselves. They are self-imposed, and although adopted pursuant to authority, it has no status as a public law. It is not a public law. It is a private law. So, sila-sila lang. Sila nababind lang. Sila-sila lang, stockholders. Pag bumili ka ng shares of stock, dinabind ka. Kasi, kasama ka na doon sa nako-cover ng bylaws. Yung mga corporate officers and directors, trustees, members, yun, nako-cover sila. But, mga tagalabas, generally speaking, no. Okay? So, how do you adopt the bylaws? Remember, the AI is approved. But, bylaws, paano siya? So, adoption of bylaws. After you receive your certificate of registration from the SEC, then the bylaws should now be adopted. By what? By the corporation through the affirmative vote of the stockholders or members, no? And dito na yung gaano karami kailangan, diba? So, ibig sabihin, stockholders, majority of the outstanding capital stock. And in non-stock, majority of the members. Diba? So, dapat pagbotohan, ina-adapt natin para ma-adapt yung bylaws. Okay? And they will be signed and they will be kept in the principal office of the corporation. And it can be inspected, no, by the stockholders or members during office hours. Para makita nila, ano ba nakalagay doon? Ano ba yung pinirmahan natin doon? Ano ba in-adapt natin? Ano nga ba ang rule natin in relation to disposal of shares, etc., etc. Yun ang nakalagay ito. Okay? Can bylaws be adopted prior to the issuance of the certificate of registration or prior to incorporation itself? Okay? Yes. Okay. Posible. Gusto mo, diba, bida-bida ka, sabi nga natin, pwede nga naka-attach na sa AI, diba? Kompleto na. Kasi, actually, it shows seryoso kayo. Seryoso yung incorporators na talagang mag-incorporate kasi kinompleto na nila. Pwede yon. Pwedeng mangyari. However, the bylaws will only be effective after, okay, the SEC issues a certification saying that the bylaws are not inconsistent with the law. Kasi if there's any inconsistency, no, any illegal entry in the bylaws, then it will be void. That particular provision will be void. So whether you submit it before incorporation or after incorporation, any provision in the bylaws which is illegal or contrary to the code, diba, or basta may pagkakamali, it may be considered as void. Okay. Now, what are usually included, no, in the bylaws or the contents of the bylaws? So we have what? The time, place, and manner of calling and conducting regular or special meetings. Very formal to. Okay, hindi to basta, mag-meeting tayo na, now na. No, there is a process. There is this procedure that is going to be followed, and it should be in the bylaws. Okay? Second, the time and manner of calling and conducting the regular special meetings of the stockholders or members. So, yung una, directors and directors muna and trustees. Yung pangalawa, paano kapag yun ang mga regular, mga members na regular special meetings of the members or stockholders. Then, the required quorum should also be in the bylaws. Diba? Kung quorum nyo ba is simple majority, diba? O gano'ng kadami yung pag-present, o kahit na pag-proxy ba, hindi mo bibilang sa quorum kung proxy ang pinarating. Allowed mo ba ang proxies in the first place? So, yun, kasama din yan. The form for proxies, na qualifications, duties, and compensation of directors or trustees, officers, and employees. Pero again, okay, nasa bylaws yun, pero meron pa rin separate rule. Diba? Ang ating batas dyan, kung ano yung mga qualifications sila. So, it should not be contrary. Pero pwede kang magdagdag ng qualification if you want to. Pwede mo i-tweak yun. Kunwari, sa halip na maluwag na ngayon kasi sa residency requirement, but the corporation still would want to adopt the old strict rule on residency. Pwede naman yun. Diba? Basta gusto mo. Basta hindi pwede na, na maging violative of the existing laws and rules. Okay, so manner of election or appointment of corporate officers or directors, etc. Manner of issuing stock certificates, annual elections, and other matters. Yan, nandun lahat yan sa bylaws. And next is, how do you now amend? Kasi syempre, di ba, hindi naman yan cast in stone. So, pwede mo pa rin i-amend. Kung yung AI nga, pwede mo i-amend eh. Diba? You just have to follow the rules on amendment. But, what about bylaws? Can you also amend? Yes. So, by a majority vote. Of what? Of the directors or trustees and at least a majority of the outstanding capital stock or at least a majority of the members in a non-stock corporation. So, laging may ganun. May botohan. Yung sa directors and trustees and meron din dun sa mga members. Okay? At a regular or special meeting duly called for that purpose, you may amend, repeal, or adopt new bylaws. Now, the owners of at least 2/3 of the outstanding capital stock or 2/3 of membership in a non-stock corporation may delegate to the board of directors such changes. Kaya yun lang makialam. Kasi yung iba, di ba, when you become a shareholder or a member of a corporation, plus sometimes the reason why you do that, you don't want to participate anymore. You want to have as least participation as you can. Di ba? The lesser, the better. Diba? Wala kang oras dyan, wala kang panahon. So sometimes you would like to, just delegate these things, these matters to the board, of directors or trustees. They can do that, but only 2/3. Kailangan 2/3 ang mag-delegate if they want to delegate. But if not, then the default is that all changes, amendments, repeal of the bylaws, will have to have the majority. Right? It must be a majority decision of both the board and the membership. Okay? So, what happens now if you now have this amended bylaws, any change in the bylaws, diba? When you adopt that, you now have to attach the new provision, whatever, or the entirely new one if you want to change everything to the original, okay, to the original bylaws para makita yung history, yun ang purpose nun. Eto, ayun ang binago, eto. So yun, kita mo yun. Kung nakasambong pagbabago yan, 10 na rin ang naka-attach doon. Okay? It must be certified under oath and a copy must also be filed with the Securities and Exchange Commission. Okay? Attached to the original articles of incorporation and original bylaws. Okay? And even if you have already adopted it, hihintayin mo pa rin alin ang imprimatur nino ng Securities and Exchange Commission. How so? By a certification saying that the same is not inconsistent with the code. So, meron pa ring review na nagaganap. Okay? So, of course, since this is a video lecture, I cannot ask you questions and you cannot ask me questions. So let us reserve all your questions and clarifications when we meet for the face-to-face or synchronous online. I'm going to stop the discussion here because the next part, which is in relation to the recognition or disregard of corporateness, I think would require a face-to-face discussion as well as a recitation on your part. Kaya, i-reserve natin to for when I come back and we meet. So, please read all the cases in the case list which I'm going to post, okay, and which I have already mentioned also during the 2 tape na video lectures. So, take note of that, understand the cases, and also the appropriate provisions in the corporation code so that we can discuss this. Okay? We can discuss this in full if you have any clarifications when I return from my travel and we see each other again. So thank you for listening and have a good night.